Preparing for the future when you won't be here to care for your family is a challenge that all parents face. But as a parent of a child with special needs, your estate planning needs are especially complex. Your will and other estate planning documents must address the unique circumstances in planning for a special needs child. Needs like adequate lifetime care assistance, managing financial affairs as the child becomes an adult, navigating eligibility for government benefit programs, staying informed about changes in the law that may impact your plan, and organizing and advocating on behalf of your child when you're no longer here. Parents of children with special needs have to make careful estate planning decisions to coordinate all their child's legal, financial, and special care needs, both now and in the future. We work closely with your attorney and other professionals to assist you in not only developing a plan during your lifetime, but also implementing the plan after you're no longer here. There are several types of trusts to assist with special planning circumstances. Let's talk about just a handful of the legal documents you might consider in your plan. First, let's discuss wills. A will is always part of an estate plan. It ensures that your money and property are distributed according to your wishes upon your death and allows you to select a guardian for your child. Without a will, you aren't in control of where your assets will go. If your child requires more financial resources than other beneficiaries, it's especially important to prepare a will that reflects your wishes. For more basic estate planning information, check out our blog on estate planning in 2021. Next, it's important to set up your beneficiary designations. With certain assets often referred to as non-probate, you must designate beneficiaries. You'll also name beneficiaries under your will. Your first inclination might be to name your child with special needs outright as your beneficiary, but be cautious and do your research so you don't jeopardize their entitlement to government benefits by leaving them too much. And what about guardianship and conservatorships? Who will care for your child after your death? Choosing a guardian for your child is one of the most important decisions you face, and often, this person is not the same person you name as conservator. A conservator manages your child's financial affairs, which can be complex. There are a variety of laws and governmental benefit programs to navigate. Our team is experienced in the conservator role and coordinating closely with your child's guardian. It's also important to understand the law doesn't assume an adult with special needs is incapable of handling their affairs. After reaching the age of majority, which is generally age 18, your child is a legal adult, and they will be judged capable of handling their own affairs unless declared incapable by a court. Next, let's talk about trusts. First, support trusts require the trustee to make distributions for the child's support in areas like food, shelter, clothing, medical care, and educational services. Beneficiaries of support trusts are not eligible to receive financial assistance through Supplemental Security Income or Medicaid. If your child will require SSI or Medicaid, you should avoid a support trust. There is also a special needs trust. For many parents, a special needs trust can be an effective way to help their child. A special needs trust manages resources while also maintaining the child's eligibility for public assistance benefits. There are two types of special needs trusts. A third-party special needs trust, which is created using the assets of the parents as part of an estate plan, distributed by a will or living trust. And a self-settled special needs trust. This is generally created by a parent, grandparent, or legal guardian using the child's assets to fund the trust. For example, if the child receives a settlement from a personal injury lawsuit and will require lifelong care. Special needs trusts are a critical component of your estate planning if you have loved ones with disabilities that you want to provide for after your passing. The laws for special needs trusts are constantly changing, and it's important to be sure to review these complex planning tools regularly. You'll need to do some extensive research to become a well-educated advocate for your special needs child, and navigating the latest medical, educational, financial, and legal changes can be quite overwhelming. Our trust officers can bear some of the weight by helping you navigate the financial and legal challenges now and in the future. Give us a call at 641-422-1600 or email us at wealth@myfcb.bank. We're First Citizens Wealth Management, a team you can trust.